Hey everybody, your favorite red-bearded estate planning and probate attorney here. I wanted to talk to you about how to protect your estate from getting sued by your loved ones once they realize they're not receiving as much as they want. But before I dive into that, I wanted to let you know how to reach out to me. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, let's dive into the family drama that is probate litigation. So this is a video I just made. Actually, the one I just made before this one was about how a person who was addicted to alcohol decided to sue an estate to rip it apart and access the default laws of Texas, which would give that person more money to spend on their addiction. At this moment, Texas law does not. Texas law allows you to bring any lawsuit at any time. There's no way that you can prevent somebody from bringing a lawsuit. Oftentimes there's a strong misconception that if I have a no contest clause in my will, this will prevent a lawsuit. However, that just simply is not the case. In Texas, you can have a no contest clause, but really it's not that strong of a barrier, because if you think about it, Texas wants the people who actually get hurt to bring lawsuits regardless if there's a no contest clause. What if that person who actually gets hurt is actually hurt? You know, what if the person who's in charge of everything steals everything? You can't bring a lawsuit then? Like, that'd be crazy. So, no contest clauses, while they are included in most wills, don't really have much benefit or protection in Texas. However, there are ways to go about that. So, another fun fact is that there are ways to protect yourself by making sure the person that you are concerned about for suing your estate is not included in your will. There are two ways to go about it. Not include them or make them a contingent beneficiary. And I'll go through both. The first one is simply don't mention them. Don't put them in your will. Don't talk about them. They don't exist if you don't mention them in the will. So what I would do if I were you, if, like, let's say this is a child, for instance, and child C is the one you want to exclude, but you have child A and B, and they want to get 50-50. So what you would say is, at the very beginning of the will, I have three children, A, B, and C. And then you would say, I'm bequesting 50-50, 150 to A, 150 to B. That's it. That's all you have to say. You don't say, and 0 to C, or you do not, and I've said this in other videos, do not, for the love of all that is good, give $1 to C, because you cannot do that. If you do that, you will give them what's called standing. And in Texas, standing means that you have the right to be in a lawsuit. If I sue the King of England because I got in a car wreck with Joe Schmo on the highway, I don't have standing to sue the King of England, because the King of England and I have nothing to do with this. It's me and Joe Schmo. So I have to sue Joe Schmo. But I have to suffer a hurt. And if I'm never hurt in a contract, if I'm not ever listed in a contract, I cannot sue because I'm not benefiting or getting hurt by that contract. And the same thing is with a will. If you have $1 given to C, that automatically means that C now has the right to sue under Texas law and bust up the will and say whatever they want to say. They can make up whatever they want, and they can cause all sorts of problems. They'll make it as difficult as possible, and they'll try to make you settle outside of court and take a lump sum payment that's greater than $1. However, if they're not mentioned whatsoever, they are not allowed to bring a lawsuit in the first place. So if they do bring a lawsuit, again, they can, but they're going to get kicked out of court immediately. And it will make things way smoother, way cheaper, way faster, and you can just go on with the original 50-50. So if you give him $1, he's going to have the standing. He's going to have standing to sue under Texas law. But if he doesn't have that $1, if it's $0, and you don't even say $0, you just don't mention them in the bequest section, then they have no right to bring a lawsuit. So that's the first way. Again, I mentioned there's two ways. The second way is that if you still want to include them, you want to make them as a contingent beneficiary. And the reason why is because in Texas, there is a list of people who can sue, a list of people who have standing to sue to bust up a will. So that's going to include the executor, whoever is named as the executor of the estate. That's going to include beneficiaries, which I just mentioned. If they're not getting $1, they're not a beneficiary. That's going to include creditors who, you owe money to whatever. The government can sue, stuff like that. But contingent beneficiaries cannot sue. And contingent beneficiaries, well, let me correct myself. Contingent beneficiaries can sue, but they will get kicked out immediately, just like if they got $0. And the reason why is because a contingent beneficiary, for those who don't know, is where you say, all right, once I die, we're splitting up everything this way. If by the time I have passed away, this condition has happened, then this person receives whatever. So in this particular circumstance, if you're worried about C being a drug addict, you could say, if C is sober for 2 years and they've gone to therapy and they've gone to rehab for 6 months before I passed away, then they will receive 33% and everybody receives 33%. But if they don't do that, then they get nothing. That's a contingent, because it's a contingency upon them doing the therapy and the rehab and all that stuff. So if you pass away and they haven't done those things, they are getting $0. They are not allowed to receive a thing under the will, and therefore they are not allowed to sue. So they'll get kicked out. But you want those contingencies to be very, very clear. You don't want to say, they're sober, if they're feeling better about themselves, if they are treating their wives better, nothing like that. You want a substantive, like you can measure it, 6 months at a formal mental hospital, whatever, So that is how you want to make it a quantifiable criteria, because if they don't meet it, they're not allowed to sue. But if they do meet it, then it's great, because it's exactly what you would have wanted in the first place, and they're going to receive what you wanted to give them. So those are the ways that you can make your will stronger. Don't include those you don't want to include. Do not give $1 benefit, bequests to anyone that you want to exclude. And if you are trying to include them, make it contingent, but make the contingency very quantifiable. It's very easy to determine, yes, it happened, no, it didn't. So if you have any other questions on that front, this is how to make sure that, people who are trying to steal your free money after you pass away don't get it. Again, you can email me directly, Derek, D-E-R-E-K, at legionlawplc.com, or you can find me on my website, or you can go to our Contact Us page and schedule a free phone consultation directly on my calendar at www.legionlawplc.com. So with that, thanks for watching and have a great day.